Are you guys ready to go?
Judge.
Everybody ready? Yes, yes?
Yes, Judge.
Okay, how about Melissa Presson? Presson?
Good morning, Judge.
How are you?
North Broward, Judge.
North Broward.
Hey! Say hi to the judge, stand on yet. Hello?
Hey, Miss Preston, you've got, you're Miss, you're not, Penton? Okay, we'll do you, then we'll do yours first. Ms. Penton, you got an outstanding capias for failure to appear.
Uh-huh.
Actually, no, it's just for a misdemeanor.
Yes, it is.
No, Penton. Melissa Sue Penton. Thank you, Ms.
You
Jackson.
got an outstanding capias for failure to appear on an alcoholic beverage violation. Your bond on it set for $500.
I don't have any way. I'm homeless to pay it. Can I get it settled today or?
Good morning, Judge. How you
How are
doing
you?
this morning?
Good.
I'm well. George Odom standing in on behalf of Mr. McLawrence. I'm going to first ask the court to find Ms. Penton to be indigent and then ask the court to appoint Mr. McLawrence to her municipal ordinance case.
I'll find her to be indigent based upon her statement that she's homeless.
Okay, thank
And I'll
you, Your
appoint
Honor.
Mr. McLawrence to represent her.
And I'll have an order provided to Ms. Jackson here shortly. Second, Judge, I am going to ask in light of Ms. Penton's statement, she was picked up on this a few months back, failed to appear, and we are here today because it's I believe it was a Colt 45 she was believed to be in possession of at the time, 8-ounce can over there by West Side convenience store in Fort Lauderdale. I'm going to ask the court, to my knowledge, there's nothing else pending in this matter. Will the court get involved and allow her to resolve this case today?
Your Honor,
Yes, who's talking?
Deputy Nethery at North Broward. Are you on Preston or Penn?
I'm doing Pendon. She said she was Penton.
Yes, you're absolutely right. Okay, I just want to make sure we have the right body here because they come out with the wrong name.
Okay, that's fine. That's fine. Yes, I'll get involved. What do you want to do?
Judge, can the court offer a withholding court costs?
That's fine. Do you want to resolve it today, ma'am?
Yes, yes, Your Honor.
It would be a withhold of adjudication and court costs that you're obligated to pay. Understand?
Yes, I do.
Do they have anything they go over with them with regard to their rights or no?
Judge, if you
Downstairs?
if you want to go through the standard
Okay.
colloquy.
Ma'am, this is what you need to understand. You're by accepting the offer today, what's going to happen to you is you're waiving your right to trial, you're waiving your right to fight it, you're waiving your right to appeal it. Understand that?
Yes, I do.
Okay, you've got a lawyer here. You want to talk to your lawyer real quick, or you want to do it this way?
It's fine this way.
Okay. Okay, court will withhold and court costs on Miss Penton.
Thank you, Your Honor.
I did find probable cause, and then I did that. Okay. How about on Miss Preston? Miss Preston?
Your Honor, can we put her on recall? I'll have her here in a few minutes.
Yep, we will. Thank you. How about Latrice Underhill?
I believe she said Paul Ryan.
Paul Ryan, Your Honor.
Miss Underhill?
Good morning.
How are you? You've got an outstanding capias for failure to appear based upon driving while license suspended. Is that something that, no, you guys don't cover it. Who does that one? PDs or no? You don't do misdemeanors?
Judge, we do misdemeanors.
What do you want to do with her?
Judge, I understand from my conversation with Ms. Underhill that she'd like to try to post a bond, so I think the bond is set at 500.
Okay,
And I think there's a status hearing that's set on Wednesday, just per the docket.
okay. Court will, her bond set at $500. Court does find probable cause. What is that?
Thank you, Your Honor. Thank you.
Okay, thank you. And Zach Zacharinda?
Judge, I see that she's in North Broward, but I spoke with them earlier. They said that she's going to be a medical reset.
Okay, then she'll be reset.
Your Honor, she is going to be, she's in 48 to 72-hour isolation, so we can't even reset her for tomorrow.
Okay, then set her down for the next day. That's 48 hours from today or 48 hours from yesterday?
48 hours from this morning. She's in an isolation cell.
Okay, then sit her down for Wednesday? That should do that? Okay. How about Sanez Aziz?
Main jail, Your Honor?
Your present judge at Maine?
Maine? Okay, got it. Court does found probable cause with regard to the arrest based upon, she's got an outstanding capias for driving while license suspended. Her bond set at $500.
Yes, Judge, and I talked to Ms. Z. I'm going to contact her boyfriend, bond her out.
Okay, thank you. How about Tracy Cousins?
Ms. Cousins is approaching Judge. She's here at Maine, and she declined the services of public defender.
Say that again.
She declined, Your Honor. She's in Maine.
Yes, fine. At Maine.
She's in Maine? Okay, is this, what did they
She
say?
declined the public defender, Your Honor, but she's still present. She can go through magistrate.
Okay, Ms. Cousins, you're, got two separate counts. You're charged with fraudulent use of an ID of another person without consent and possession of a counterfeit driver's license or ID. Court does find probable cause with regard to each. Your bond set at $1,000 on each. Thank you. Erica Lovesmith,
That's North Broward.
North Broward, Your
thank
Honor.
you.
Come on in, Ms. Lester.
Ms. Lovesmith, you're charged with possession of cocaine, possession of drug paraphernalia, and violation of a municipal ordinance.
Judge, I didn't have the opportunity, well, I don't know. I didn't have the opportunity to speak with her before magistrate. We called, she wasn't quite available yet, so I don't yet have the facts to populate her ties to the community. If I could just put her on a brief recall, I could call up there and get some more information for the court to help set a bond.
Okay, we'll put her on recall for a little bit.
You're going to answer your phone this time, right?
Yeah, we will.
172.
Okay. I see it's still jovial. Go ahead. On Sinellis? Try earth it. Sinellis,
Mr. Ellis is here, present judge at Maine.
Maine. Got it. Mr. Sinellis, you've got an outstanding warrant for your arrest based upon a violation of probation. Court does find probable cause with regard to the violation of probation based upon the warrant. You have a no bond. You're going to be set before Judge McHugh. I need to sign it. I keep forgetting to sign it. Thank you, sir.
Thank you, Judge.
On Burrow Clog, Richard Burrow Clog,
Conti, Your Honor.
Conti. Mr. Burrow Clog, you've got an outstanding capias for the city of Hollywood for trespass. Your bond on that set at $100. Court does find probable cause with regard to it.
Yes, Your Honor.
So you're gonna have to post bond. On Nicholas Register,
Mr. Register, come on up, please. He's here, present judge at Maine. Say first of all.
Mr.
He's here, present judge at Maine.
Okay, oh, I thought you were holding the button so I couldn't hear. Okay, Mr. Maine, you've got an outstanding warrant based upon a violation of probation. Your bond set, you have no bond, and that's to be set by, you'll be brought before Judge Levy. Court does find probable cause based upon the warrant. Terrence Walker,
Mr. Walker.
Mr. Walker, you two have a outstanding warrant based upon a violation of probation on the crime of petty theft. Your bond set at $5,000 by Judge Melinda Brown. Court does find probable cause based upon the warrant. Kristen Rawlings.
Judge, I just want to tell you, I've had the opportunity to speak with Miss Lovesmith on page 3. I'm ready to recall that whenever the court is.
We'll do it right now. Erica Lovesmith.
She's up in North Broward, Your Honor.
She was where?
North Broward.
Good statement again.
Hey, Miss Lovesmith.
Hello, how are you?
Again, you've got a outstanding, well, you were arrested for the crime of possession of cocaine, possession of drug paraphernalia, and a municipal ordinance. Let me hear from public defender.
Judge, do you find probable cause as to the counts?
I do find probable cause.
Your Honor, from what she's told me, she's already been screened by pretrial release, and from what she's told me, they believe that she's a good candidate if the court is so inclined. She's lived here in South Florida for 11 years. Unfortunately, right now she's unemployed. She lives down in Hollywood. She has her sister and her mom that live in the area as well. She cannot afford the $1,000 bond on the possession charge. Obviously, Judge, it's an 893 offense and a municipal ordinance, so we'd ask for pretrial release in this case.
Your Honor, Eric Linder on behalf of the state. I don't believe Ms. Lovesmith would be a good candidate for pretrial. She was arrested May 15th of this year for possession of cocaine and drug paraphernalia, and she was released ROR June 20th. And I would note the state has not made a filing decision, but the charges are still pending. But in addition to that, 2014 resisting without violence and prostitution, 2014 burglary of a dwelling and grand theft. She violated her probation, was sentenced to just under 39 months state prison. Theft 2013, drug paraphernalia and theft 2012.
Okay, court's going to deny your request for pretrial. Her bond will be $1,000 on the possession of cocaine and the possession of drug paraphernalia and the municipal ordinance. Court's going to ROR. On Kristen Rawlings.
Mr. Rollins, is your present judge proposing a municipal ordinance?
He's on, where's he, main jail?
Main jail.
What happened to Mr. McLawrence's associate?
I believe because this is a Hollywood case,
Oh.
Lawrence represents Florida. I believe it's Mr. Stephen Shake that represents Hollywood.
Yes, Judge, it's Steve Schaaf, is my understanding, who's the PD, not PD, but the attorney appointed from those municipal ordinance cases.
What do they usually do with him? I've got an outstanding warrant.
Yeah, as a friend of the court, I know in speaking to Mr. Rollins, he's interested in asking the court if you would consider resolving his case today for time served, but I believe Mr. Rollins is going to be asking you that.
Yes, sir. I was asking if you wanted to resolve my case by time served.
Okay. Is that what you want to do?
Yes, sir.
Okay. These are the rights that you have. You have the right to a lawyer. You don't have one now. Understand that? You're going to be waiving that right. Understand?
Yes.
Okay. Because I can reset you for tomorrow and they'll get you a lawyer.
Excuse me?
I can reset you for tomorrow and they'll get you a lawyer if you want.
Oh, no, sir, no.
Okay, so you're going to be waiving your right to a trial. You're going to be waiving your right to a lawyer. You're going to be waiving your right to fight this. You're going to be waiving your right to appeal. You're admitting the charge and you're taking a time-served sentence and be obligated to pay court costs. Is that what you want to do?
Yes, sir.
Okay. So with regard to the outstanding crime of loitering, how do you plead? Guilty or no contest?
No contest.
Court accepts your plea. Court finds you to be alert and intelligent. Court finds you freely and voluntarily entered your plea without threat or coercion, with the full understanding of its legal effect, and I'll sentence you to time served and court costs. Okay, anything else? Nope, good. Next, Sunrise arrestee, please.
North Broward, Your Honor.
Thank you. Okay. Mr. Arrestee, you're charged with the crime of resisting an officer without violence and trespass. Finds probable cause with regard to the charges.
Judge, I spoke to this individual. He's told me he's lived here in South Florida for the last 2 or 3 years. Unfortunately, right now he's not working. He lives in Sunrise with his grandmother. It is a resisting without violence and a trespass. Would the court consider placing him on pretrial release? He's told me he's unable to afford that $1,000 bond.
Mr. Linder?
Your Honor, the only issue is, I mean, he refused to give any information. I mean, they book him under Sunrise arrestee. You can't possibly check a criminal history. I don't know if he has a record. We don't know anything about him.
That's true. Okay, Mr. Arrestee, court's going to deny your request for pretrial because we don't know who you are. Your bond set at $1,000.
Judge, he's
I gave my social security number.
Okay, well, they don't have any way of knowing who you are if you don't give them your name and all that information.
No, I gave my
Hold
name.
on.
That is true.
Then I'll reduce it to $100. Thank
And
you.
also, can I say something? Sorry. If you're-
sir, I'm going to advise you not to speak about the facts of your case. This is all being recorded right now.
I'm aware of that, and thank you for the advisement. But I would like to emphasize the fact that I live with my grandma on the premise where you say I was loitering. That's where my grandma lives.
Okay, well, if you don't give them any information, they're not going to be able to do anything to stop it. So you'll have to deal with that at the time of filing if you intend to file it. But your bond's $100.
All right, thank you.
Travis LeBird.
Mr. Levert is present here at Maine, Judge. I've had an opportunity to speak to him. He informed me his mother will be bonding him out.
Okay, Mr. LeBird. Court does find probable cause with regard to the charge of resisting without violence and trespass. Your bond set at $100 on the resisting and ROR on the trespass.
Good luck, sir.
On Ryan Johnson.
I've been informed, Mr. Johnson's the medical reset, Judge.
Okay. Reset him for tomorrow. How about Wunderlich? Bradley Wunderlich?
Bradley Wanderlich is here.
Mr. Wunderlich, you're charged with trespass.
Drop it off at your, or yeah, fine.
Did they do it as a municipal ordinance, or they did it as a?
This is a state charge.
Okay. Court does find probable cause with regard to the trespass based upon the allegations set forth in the probable cause affidavit. Your bond set at $25, sir.
Thank you, Judge.
Mr. Wayne Agate.
Mr. Wayne Agate, come on up, please.
Judge, I've got probable cause argument as to count 2.
Okay, let me look at it real quick. That's the resisting?
Yes.
Your probable cause argument is?
Judge, I don't see the act of violence that would conduct the resisting with violence aspect. According to the allegations, it looks like there's a dispute at a Nick's bar. Mr. Agati, I guess, is asked to leave that, and he gets into a dispute with the officers that are involved. It looks like it's the police that initiate the physical contact with him. And despite that, there is no violence from what I'm reading here done by Mr. Agati towards the police officer. I think the closest thing that I saw, unless I missed something, is when he allegedly, quote, got in the face of the sergeant and motioned with his hand in the face of, but that's very different than punching or touching or striking. It appears that in response to that, the sergeant pushed him back, and then the police officers began to place him into custody. The other acts that I saw were him allegedly tensing his hands, pulling them to the front, and I think I saw that he was clenching. There it is, tensing his arms and attempting to move his hands. I don't think if those allegations, if true, warrant the violence aspect of it. I think if anything, this could be a resisting without violence. So I'm asking the court not to find probable cause on count 2.
Your
But the
Honor,
last sentence on the page. Go ahead.
well, I was going to be relying upon the first sentence, Your Honor, on the third page, that resisting with violence doesn't require punches to be thrown. It just requires resisting with force as opposed to running. That he was using enough force that bystanders had to come there and hold him down so the officer could arrest him, I think is enough resistance with force.
Court does find probable cause with regard to resisting arrest with violence based upon the allegations set forth, together with the conclusion that's set forth at the end. With that,
With that being said, Your Honor, I defer to Mr. Romero for ties to the community, but I'd ask the court to keep this particular allegations as it pertains to the resisting with violence in context in setting a bond for count 2.
and I also find probable cause with regard to count 1. Go ahead. Yes.
Speaking with Mr. Gate, he's 32 years old. He works in the construction business. Whenever he gets work, he makes approximately $10 an hour. He's been doing that for the past year. Financially, he has no money to make, no property. He lives in Coral Springs with his girlfriend. Since he's having a tough time with financial resources, his girlfriend is helping with all the expenses. He's going to be contacting his girlfriend to help post his bonds. Judge, considering his lack of financial resources, I'd ask you at this time, and considering my colleague's argument as far as the strength of the case that's before you, or lack of it, I'd ask you to consider setting a $500 bond on Mr. Gate's behalf.
Yeah, I'm just checking with pretrial to see if there's any criminal history.
His only previous history is out in New York. He was arrested back. He was convicted in 2012 for disorderly conduct.
Okay.
2015, he was arrested in New York for aggravated driving while intoxicated. There's no disposition on that charge.
Based on his history and allegations, state would be requesting a $1,000 bond on count 2.
Set the bond at $500 on count 2.
Thank you, Judge.
Your Honor,
Yes?
I have Miss Preston Melissa up at North Broward now.
Okay, thank you.
Judge, I forgot to ask Mr. Gate to sign a photo order.
Which individual was that?
Mr. Gate, I forgot to ask, would you sign a photo order?
Yes.
Thank you, Judge.
On Miss Preston.
Good morning.
How are you? Miss Preston, you've got outstanding capiases on resisting without violence for your failure to appear. It's set at $50,000. On the DUI, it's ROR. On the DUI, it's ROR. On the driving while license suspended, it's ROR. On the DUI, it's ROR. On the DUI, it's ROR. On the driving while license driving under the influence, it's ROR, and leaving the scene. However, on count 1, the resisting without violence, your judge set it at $50,000. You've also got a no bond capias for another driving on the influence based upon a warrant, and that's set also at no bond. So the court does find probable cause with regard to it based upon the capiases and the orders that are before me. On Georgie's Celador,
He's here present, Judge, in Maine.
Maine.
What's that?
Georgia Salazar on page 6 at Maine.
I see it.
I appreciate it. Just let me know you don't have to.
Okay, This going to have to be reset for tomorrow, because one of the witnesses that are set forth in the probable cause affidavit is somebody who I know and somebody who I represented a number of years ago, so I don't feel comfortable doing it.
That's fine. Can we just reset them to the PM docket?
Oh, yeah, we can
There'll
do
be a
that.
different, you're not
I'm
doing,
not doing PM. Okay, so reset them for the PM docket.
okay. Mr. Romero, did you get that for Miss? We can't hear you.
I'm gonna explain it to Mr. Celador.
Yeah,
Okay, very good. Thank
it's
you.
Felix Garcia, so that you guys know. Brent Caraway.
Mr. Caraway is here present, Judge, to decline the service of public defender.
He declined the public defender? Okay. Court does find probable cause with regard to the crime of battery on a law enforcement officer. Also finds probable cause with regard to resisting. Court's going to set the bond on battery on a law officer at $2,500 and the resisting at $100. On Malcolm McFadden.
Mr. McFadden is approaching, Judge.
Okay, Mr. McFadden, you've got an outstanding warrant based upon a violation of probation. Your bond set at no bond. Court does find probable cause based upon the warrant for violation of probation. You'll be brought before Judge Lynch. Marcus Pratt.
Good luck, sir. July 12th, you'll be senior judge.
There's a VOP.
Mr. Pratt, come on. Mr. Pratt is approaching, Judge.
Mr. Pratt, you're charged with robbery by sudden snatching. Court does find probable cause with regard to the crime of robbery by sudden snatching. Your bond set at $3,500, sir.
Judge, if the defense could be heard.
Sure.
In speaking with Mr. Pratt, he's been residing in South Florida his whole life for 18 years. At this time, he's unemployed. He's currently looking for work. He lives with his grandparents in Deerfield. He's a graduate of Deerfield Beach High School. He just graduated this year. He plans on attending FIU college spring of 2018. He took the ACT and the SAT. He only scored 1,000 on the SAT, so he plans on retaking it again. He graduated with a 2.7 GPA, and hopefully once he gets his scores high enough, he'll be accepted into FIU in spring. He's a registered voter here in Broward County. He's attends St. Mary's Episcopal Church. He's been attending there his whole life. He volunteers there. He's been attending with his family roughly his whole life and volunteering. Judge, from what he told me, his parents, like I said, they're elderly. Only his grandmother works. So financially, $3,500 is going to be out of his reach. What we'd be asking you to consider is to consider setting a bond of potentially $1,000 with some sort of standard free trial That way, that would alleviate any of the court's concerns. He'll be monitored by BSO, and that's what the defense would be requesting at this time, Judge.
State would be requesting that Your Honor keep the bond at $3,500. While I understand Mr. Pratt was arrested for robbery by sudden snatching, I think it's a very reasonable bond considering the allegations would seem to really seem to go more towards a strong arm robbery since force was used against both alleged victims.
Court's leaving the bond at $3,500.
And Your Honor, the state would request a release condition of no victim contact.
There'll be no victim contact with Miss Ogley. What was the name on there?
I think they're Ogle and Virginia Thomas and Deborah
Ogle and Thomas.
Thank you, Judge.
Yes, Judge.
Is this one a domestic or no? Brazil? Brazil?
Mike Bazil, come on.
I had the same thought, but it's not flagged that way.
It's actually, you know what, I wasn't sure at first, but I guess I just don't know if any of the charges satisfy domestic violence qualified offenses. I don't know if but I mean, it's definitely a domestic relationship since they have a child in common.
Okay.
That being said, Your Honor, when the court's ready, if I could address count one.
I'd like to address that one as well, but I also want to address as to probable cause count
Let me
three.
just finish reading real quick. It's a crowded room.
Your Honor, if I may,
As to the burglary.
as far as count one, as listed, it's a punishable by life offense, but it also would appear that it's an attempt, since it does not mention that any entry was made into the room, so he would be bond eligible. Frankly, from what I can tell, in all candor, it would seem that 1 and 2 stem from the same incident, so I have no objection if the court is inclined to find no PC on count 2. There's no mention, I don't know if the officer was concerned the hotel, but it doesn't mention that he went any place in the hotel that wasn't open to the public. So, and I think I'll beat Mr. Goldberg to this. As far as the child abuse, Your Honor, I'm not trying to make Mr. Goldberg's argument for him, but it doesn't really
I'll tell you what I already did, so you know. I didn't find PC on 2, and I didn't find PC on 3.
And
I can find PC on 4, but there's no value.
well, it does
So I
mention that the estimated damage, it's in the, I believe the last sentence was
$5,000?
estimated at 5,000. Well, I guess it's from the door not being broken, the window, the glass window being smashed.
And Judge, I would ask that if you're going to find PC as to count 1, I mean, I don't have the statute book in front of me, but I would presume that count 4 is subsumed by count 1. That's a burg with the damage over $1,000. Count 4 is the damage over $1,000. So
I think there's PC. I mean, for bond purposes, I obviously have no objection if Your Honor wants to take that into consideration when setting the bond on count 1. And then the ROR, I wouldn't have an objection to the ROR on count 4. And, but I agree with the court. I'm not going to be asking for any time to perfect on counts 2 or 3.
Okay. Okay, on count 1, court finds no PC on count 2 and count 3. Court does find PC on all the other counts. On count 1, court's going to set the bond at $3,500.
Judge.
On count, hold on, 4, I'm going to set it ROR. Okay. On count 5, I'm setting it at $1,500. On count 6, 100 is set, and on Count 7 is $2,500, yes.
What was the bond on count one that? the
30,
court said?
3,500.
If I can have one brief second, Judge.
By my count, I think that's 7,600 total, Mr. Romero.
Good guess.
Judge, I just finished speaking with Mr. Bazile, and I got some background information earlier. I just wanted to confirm some of the information I received. And speaking with Mr. Bazile, he's been living in our community for the past 7 years. He is 20 years old. He is working. He works at Winn-Dixie. He's been working there for the past year, making approximately $10 an hour. At this point, Judge, he has no money in bank, no property. He lives in Fort Lauderdale. The only person that's going to be able to help post his bond is going to be his mother. She lives in Wilton Manors. She's a housekeeper by trade. That's why I was trying to inquire as far as how much his mother makes. I believe $7,600 for his mother is going to be out of their reach. What I'd be asking you to do, Judge, is lower it from $7,600 to what I believe that if you do all the math, to potentially about $3,000. $3,000 is going to be something I believe his mother will be able to help post his bond with.
Okay. And what's his history?
Well, Your Honor, he was arrested last year on 2 counts of domestic violence battery. Those were both dropped. Without going, he has a similar prior to that as a juvenile that he went through a diversion program on. Your Honor, the state would be, based on the numerous allegations and the severity of some of them, the state would be asking, Your Honor, to keep the bonds where you set them. We'd also be asking for no victim contact, but we'd understand that that would not include the juvenile with initials MB, since the court did not find probable cause for that count.
I'm gonna leave the bonds where they're at. No victim contact with J. Brown.
Thank you, Judge.
Okay, with regard to Florinatus, Leonaldo,
Come on up, please. Florinatus? Yes.
okay, Mr. Florinatus, you've got an outstanding warrant for your arrest for a crime of armed burglary of a dwelling and kidnapping. Each of the individual charges have been described in the affidavit to arrest that was signed by Judge Tobin Singer. Your court does find, based upon the application, proof, evident, presumption, great with regard to the charge set forth in count 1 as well as count 2.
Your Honor, I know Judge Tobin Singer set a $500,000 bond on count 2, and this is probably a moot issue, but just for form, since count 2 is also a punishable by life offense, and the court making the necessary finding, would the court be inclined to change that to a no bond?
Leave it the way it is. So he's going to be held no bond on count 1, his bond on count 2 set at $500,000.
Your Honor, we just asked for an order of no victim contact.
No victim contact with regard to. Cynthia Baez. On Bradley Royez. Bradley Royez.
Judge, the only thing I'd be asking you on behalf of Mr. Floriantis is would you sign a photo order?
Yes.
Thank you, Judge.
How about Bradley Royez?
Mr. Roy is approaching.
Mr. Royez. You've got a whole bunch of outstanding cases and a whole bunch of violation of probations.
Actually, Your Honor, if I may,
Go ahead.
on counts 2 through 7 as an officer of the court, those are all under Florida Statute 94806 for warrantless violations. I reviewed the probable cause affidavit, and I don't see any allegation that any allegation that would support that he violated his probation.
What you got? You got a 948 hold, you got a capias, the court does for a misdemeanor, I've got that.
The capias on
Picked up
count one,
that.
yes, there's nothing
That's
that.
$500.
But
Okay, and then you've got, oh, it was a capias. Okay,
yeah, 2 through 7. I have to, I'm
That's
duty
fine.
bound, so I think he has to be ROR'd on 2 through 7. It just doesn't mention anything that would have been considered a violation of his probation that I can see.
arm on all the charges that he's on
2 through 7, right?
probation for, and his
Okay.
bond said $500 on the, there is probable cause that he's on probation in all these cases.
Well, Your Honor, here's the
No,
thing.
no, I understand that. I
Well,
understand.
no, the reason, and the reason why it's significant that the court would have to find no PC, if the court does find PC, then he would have to be held no bond. Since he's on probation on one of the counts of burglary of a dwelling, he would qualify as a violent offender of special concern, and only Judge Lynch could grant him a bond.
I'll just allow him to be RR'd on those.
Thank you, Judge.
And then $500 on the capias.
Courtroom. Hey, Andy.
How about on Siddiqui Clark?
Mr. Clark, come on up.
As soon as I'm done. Okay, cool. Siddiqui Clark.
Judge, I would just have a PC argument as to count 1.
Okay, go ahead.
Judge, I've got a probable cause argument as to count 1, the possession of a weapon by a convicted Florida felon. There is no observation by any of the officers or the witnesses that Mr. Clark is in actual or constructive possession of the firearm. The best that they have is he's allegedly, quote, continuously reaching into his waistband, possibly reaching for a weapon. There's no observation that he has this weapon. They do allegedly locate a firearm in the grass of the yard. However, again, no one saw him with it in his waistband. No one saw it with him in his hands. No one saw him with the firearm dropping it there. We know that there are several other non-law enforcement officers in the area. At the very least, this Miss Williams, possibly the 1-year-old daughter, and the witness that's in the area, Judge. There's no allegation here that Mr. Clark was ever in actual or constructive possession of the firearm, so I'd ask the court not to find probable cause as to count 1.
Your Honor, and for probable cause purposes, I think there is enough for the law enforcement to have probable cause. He was seen reaching to his waistband when running. From the area from where he fled is where the gun was found. It should be worth noting, it would appear from the evidence that it had just been placed there, considering it was in an area where the area was still wet, but the gun was dry. I understand that probably for charges to be filed or for him to be convicted, more might be required, but I think it's enough for probable cause.
Court does find probable cause with regard to each of the individual counts based upon the allegations that are set forth in the probable cause affidavit, as well as court does find that he's got a violation of probation for a no bond warrant, an outstanding violation of probation and community control for a no bond warrant, and an outstanding hold out of Dade County for no bond. As such, court's going to set the bond as follows. On count 1, it's $2,500. On count 2, it's $100. On count 3, it's $100. On count 4, it's $100. On count 5, it's $100. And on count 6, 7, and 8, he's to be held no bond based upon those violations and outstanding warrants.
Judge, if the defense could be heard as far as mitigating circumstances to reduce the bond. And speaking with Mr. Clark, he's been residing here for 22 years. At this time, he's unemployed. He's currently looking for work. He lives in West Park with his girlfriend. His girlfriend is helping with the expenses. She currently works at Burger King, making minimum wage. She's the only person that he could call to help post his bond. What I'd be asking you to consider is, Judge, setting a bond on count 1 of $1,000, ROR the rest of the remaining counts. That way, he'll be in a position, as girlfriend could, to post his bond. The no bond hold will still be in place. Dade County would have to come and pick him up. These charges aren't going to be filed for at least 30 days. Then he'd have an opportunity to already start addressing his violation of probation felony hold in Dade County. So, Judge, respectfully, that's why we'd be asking you to set $1,000 on count 1, ROR the rest of the counts, and ask you to sign a photo order as well.
Your Honor, I don't believe the aggravating factor that he's currently out on probation on 2 separate felonies in Dade County outweigh any mitigating factors.
Court's going to leave the bonds as set.
Thank you, Judge.
Okay, thank you. On Medina Cruz, Jorge Medina Cruz.
Mr. Medina Cruz, come on up, please.
Mr. Cruz, you've got an outstanding violation of probation warrant signed by Judge Fine. Court's going to find probable cause with regard to that. You're going to be held no bond on that and brought before Judge Fine.
Good luck,
Thank
sir.
you.
You'll be seeing your judge July 17th at 8:45. Okay?
Lyndon Harris.
Mr. Harris, come on up.
No. Well,
Hold on. I can't.
Ms. Romero, can you turn the microphone off, please?
and, Your Honor, if I could address the court before any determinations made.
Which one are we on?
Lyndon Harris.
Oh, misdemeanor battery. Okay.
Ca-
Oh, hold on.
Sure.
Now we can go back on. Can he hear us? Yes?
They can hear us, Judge.
Okay, so go ahead, Mr. Lyndon.
Your Honor, I checked in Odyssey. Counts 3 and 4 are, it's a not in custody capias that's been assigned to Judge Cohen. So they're domestic violence. I think that they should be reset for the first, since Judge Cohen is now handling felony domestic violence first appearances, the matter should be reset to go before him.
Counts 3 and counts 4?
Yes, Judge.
It's a pending open case is what it is?
It's a not in custody, Your Honor. When the, when,
Okay. That's fine. I'll set it.
I'm sorry. The only thing that I would say, I mean, what would be the timeline that he gets in front of Judge Cohen? The reason I ask is,
Let me do what I need to do first on the first two, okay? Court's going to find probable cause with regard to possession of cannabis, and his bond set at $100 on that. On the other one, the window violation, doesn't even require a bond. And
because if it's just the filing of a not in custody capias, I mean, he would be entitled to a bond on both
right,
counts
but he'd
3
have
and
to have
4.
it set before
Before his judge.
his judge, which would be the domestic violence judge. So
that would be tomorrow morning, Your Honor, and my understanding under the rules of procedure, he has to have his first appear for a first appearance within 24 hours, which he has today. A PC determination only has to be made within 48 hours, which if he sees Judge Cohen tomorrow morning at 11, that will be within the 48-hour. It will survive procedural scrutiny.
Then Judge Cohen can handle it tomorrow morning. That's where you have to be held in order to be able to set a bond. Okay. So the last two get set before Judge Cohen tomorrow morning. How about Calabrese, Christopher? Calabrese, Christopher? Is that this gentleman in front of me? No?
All right,
Can somebody
Judge,
turn on his mic?
that's still Mr. Calabrese. I had Mr. Romero on the phone about Mr. Harris.
He's coming. He's walking.
He's
up.
coming.
We were actually discussing what happened. I didn't hear what happened, so I wanted an opportunity to tell him exactly what happened.
Not a problem, not a problem.
Judge, as far as Mr. Calabrese goes, he has private counsel. He has Mr. Neil Kirsch.
Okay, then Mr.
So I
Calabrese,
can go ahead and talk to Mr. Harris.
you're charged with possession of cocaine, possession of alprazolam, and possession of cannabis. Your bond on, the court does find probable cause with regard to each. Your, on possession of cocaine, your bond set at $1,000. On possession of alprazolam, your bond set at $1,000. And on the possession of cannabis, your bond set at $100. So you need to get a hold of your lawyer, or you can bond out. Okay, thank you.
Thank you, sir.
Matthew Huey? Matthew Huey?
Mr. Huey's your present judge of Maine?
Judge,
Okay, with regard to Mr. Huey, court does find probable cause with regard to.
Judge,
the
I've got
possession-
a PC argument on to Mr. Huey.
Go ahead. I need the microphone quiet, thank you.
Yeah, that's, Judge, there's no allegation in the probable cause affidavit that I saw about the weight of this. All that shows at the very end is the count that he's arrested for, marijuana possession over 20 grams, but nowhere within the probable cause affidavit does it make an allegation as to the weight. Without any weight, I think the presumption would be for lenity in favor of the defendant. There's no allegations that it would be a felony. So I'd ask the court, if the court's going to find probable cause, I'd ask the court to find a probable cause for misdemeanor amount of marijuana.
I have no objection to that.
Court does find probable cause with regard to the marijuana, I did see that, as to amount. Court's gonna set it at $100 the bond. It's misdemeanor. Arnold Ismail? Arnold Ismail?
Ismail, come on up, please.
I do that every time.
How much money?
Yeah. He's your present judge of Maine.
I'm not.
Where's he? Ismail?
He's in Maine jail, Your Honor.
Okay.
Maine jail.
Is this Mr. Ismail?
Yes, Judge.
Okay, Mr. Ismail. You're charged with possession of cannabis as a misdemeanor and possession of cocaine within 1,000 feet of a business or convenient business?
It's a church.
Church, you're right. 900 feet. Okay, with regard to Mr. Ismail, court does find probable cause with regard to the misdemeanor cannabis and possession of cocaine within 1,000 feet of a church. Set the bond on the possession of cannabis at $100. And the bond on the possession with intent to sell or deliver within 1,000 feet of a church at $7,500.
Judge, in speaking with Mr. Ismail, he did advise me that he can't afford the bond as,
All the money I've been making,
hold
I
on,
sent to my kids.
hold on. Judge, right now, he doesn't have anything stable. He gets odd jobs whenever he can. He lives with his girlfriend. Whenever he gets any sort of money, he tells me he has kids, he sends it to them. Hold on. His girlfriend works as an insurance agent. Right now, he believes he doesn't think she can come up with the full amount of $7,500. Respectfully, Judge, he'd be asking you to consider reducing it from 7,500 to 5,000. He believes that's something she could be able to afford.
How much did you say?
5,000, knowing that hopefully if she goes through a bondsman, it's 10%. He thinks she has $500.
Okay. I'm gonna leave the bond as I said at $7,500. Okay, with regard to Taru Mara,
Mr. Moran.
Judge, I have a PC argument as to count one.
okay, hold on. Go ahead.
Judge, I don't know that if I'm missing a page or what, but I don't see a description of what the crime is.
It's conclusory, Your Honor. I'm going to request 24 hours to perfect.
I'll grant your request to perfect for 24 hours, but in the, okay. Well, the violation can't be a violation if there's no crime.
Thank you, Judge. I just explained to Mr. Margu that he'll be brought back tomorrow.
Okay. How about on Todd Bunch?
Mr. Bunch is here present, Judge Maine.
Mr. Bunch, you've got an outstanding warrant for your arrest based upon a violation of probation that was signed by Judge Dennis Bailey. Court's going to find probable cause with regard to based upon the warrant, and you're to be held no bond and brought before Judge Bailey. How about on Curvin's Grillis?
Judge, I'm going to have a PC argument on both counts.
Okay, let me read it. I didn't get a chance. Yes.
Judge, my PC argument as to both counts would be that it appears that those narcotics belong to the co-defendant, Mr. Bowens, on page 12. Mr. Bowens allegedly made a statement where he admits that he was the person possessing with the intent to sell both the cocaine and the heroin. Within that statement is an allegation that Mr. Gills knew about the narcotics, but that doesn't mean that he was in actual control of those narcotics. I think that and we see also when we look to page 12 that there's going to be additional counts on Mr. Bowens, but Mr. Gills is not charged with those, again, because it appears that Mr. Bowens is the one who is taking ownership of what's contained within the vehicle. So I would argue that at most, he's in the area while Mr. Bowens is committing the offense. That'd be number one. Number two, even if he did have knowledge, it doesn't appear that he has control. And furthermore, the simple possession amount, I don't believe is his possession with intent to sell, manufacture, deliver, even if the court finds that as a matter of probable cause, he was in actual or constructive possession of both the cocaine and the heroin, that it was not his intention to sell them. And so possession with intent, I don't think can be shown within this probable cause affidavit. But I don't think any possession can even be shown based upon what's contained in the probable cause affidavit.
Response?
None, Your Honor.
Okay. Court will find no probable cause with regard to Mr. Gills on each of them.
And I'm not going to ask for any time, Your Honor.
Sounds like, looks like Mr. Bowens is about giving advice.
Mr. Gillis is ROR on both, correct?
He's ROR on both.
Thank you.
Is that Mr. Bowens back there giving Mr. Gills legal advice?
No.
No. Okay, Mr. Bowens. You're charged with display of a firearm during a felony, possession with intent to sell or deliver cocaine, possession with intent to sell or deliver heroin, and possession of codeine. Court does find probable cause with regard to each. The display of a firearm is what? Is that a no bond?
No, it's bondable.
The display of a firearm is going to be $1,000. The possession with intent to sell or manufacture cocaine is $2,500. The possession with intent to manufacture heroin is $2,500, and the possession of codeine is $1,000.
Can you, Mr. Romero, can you turn that microphone, please? Say again, Judge, I'm sorry.
On count, I don't know what that is. On count one, it's $1,000. On count two, it's $2,500. On count three, it's $2,500. And on count four, it's $1,000. And the court does find probable cause with regard to all.
Judge, if the defense could be heard.
Sure.
If the state can confirm, and speaking Mr. Bowens, I believe this is his first felony offense, Judge. He's a U.S. citizen. He's been residing here his whole life. He's 19 years old. He works part-time in landscaping. He cuts grass for a living, Judge. He lives in Margate with his mother. That's who he's going to be contacting to help post his bond. His mom works for Walmart. She makes approximately, I believe, $10 an hour is what he informed me. I ask you to consider on counts 2 and 3 only, Judge, reducing it from $2,500 to $1,000 each count, making a total of $4,000 bond on Mr. Bowen's behalf, and hopefully that's something his mother will be able to afford.
First felony as an adult. He's only 19. I can go into more detail if you want to go sidebar.
No, we'll leave it the way it is. Thank you.
Yes, Judge.
Lee Risher?
Judge, I'm informed.
Medical reset.
Yep.
Mr. Fisher's back. South Carolina.
Joseph Johnny? We're good. Is that it?
I think so.
That was quick.
You got the right day. You got the right morning of the week.
Did I? I thought this is the worst morning of the week.
No. Monday,